Okay, so let's begin our discussion on chapter 3, or the subject matter of the contract of sale. So similar to the contract of sale itself, guys, subject matter of the sale has its own requisites. So first is that the thing, subject matter of the sale, must be a possible thing. It must also be licit, and it must be determinate. Okay, when we talk about thing being possible, it is one that is first already existing. It can also be one having potential existence. It can be a future thing. It can be a contingent thing, or it could be a thing subject to a resolutory condition. And when we speak about the thing being licit, then it is one that must be within the commerce of men. So therefore, there's no prohibition in selling that thing. And the third requisite of a valid subject matter is that it must be determinate. And when we speak of determinate, we are referring to a specific thing that is the subject matter of the sale. Okay, but it does not mean that generic things cannot be subject matter of the sale. The only rule is that when you are selling a generic thing, then that generic thing must at least be determinable. So take note that when any of these requisites are absent, then it can result in a situation wherein there's no contract of sale at all that will be entered into by the parties. Why is there no contract to speak of? Because subject matter of the sale is one of the requisites of a valid contract of sale, correct? So if the subject matter itself is not valid, then there's a missing requisite for the contract of sale. So therefore, there's no contract that can be arrived at if the subject matter is not a possible thing, if it's not licit, and if it's not determinate or at least determinable. Okay? So kuha nga kayong usaan nila, the result will be that there is no contract of sale. There cannot be perfection at all. So these three requisites of a valid subject matter of the contract of sale must be existing already. This must be met or complied with at the time of perfection. Otherwise, there would be no meeting of the minds. So the relevant articles discussing subject matter of the sale is in 1460 and up to 1465. Okay, so I hope you've read the codal provisions pertaining to this. So let's discuss them one by one. So when we speak of a thing being already existing and in the possession of the seller, that's discussed in Article 1462. For those things with potential existence, the rule is found in 1461. In the sale of future goods or contingent goods, that's also found in Article 1462. In the sale of undivided interest in 1463, sale of share in specific mass 64, and those things whose existence is subject to resolutory conditions, that's 1465. Okay, so considering that these things can be subject matter of a sale, how do we reconcile this with the article found in 1409, subparagraph 3? So 1409 lists the instances when a contract is considered as void. Okay? Ang kaning 1409, this is found in the Law on Obligations and Contracts. So a contract would be void under Article 1409 subparagraph 3 when the cause or the object did not exist at the time of the transaction. So, is there conflict between the law on obligations and contracts and the law on sales? Is there, guys? So, wala gid no? Nga naman, wala. Okay, if we interpret these provisions as in conflict with each other, then it's as if the law on sales, specifically kaning 1461 to 1465, are inutile provisions or of no effect. So how do you harmonize the rules then pertaining to the existence of the subject matter in a contract of sale? So the rule is that Article 1409 subparagraph 3 is not literally applied in contracts of sale. Kay 1409, that's found in the law on obligations and contracts. So that's the general rule with respect to contracts. But when it comes to the nominate contract of sale, which has its own chapter in the Civil Code, we apply 1461 to 1465. And this expressly authorizes the parties in a contract of sale to have a subject matter, things which are not yet in existence at the time of perfection. Okay? So other subject matter of sales will be kaning sale of an undivided interest. And if the subject matter is of such nature, undivided pa siya, what happens is that it will result into a co-ownership between the parties. And in the sale of share in a specific mass, then 1464 provides the rules on what extent ownership is acquired. Kay what is being sold here is just a share in a specific mass. So I hope you're able to answer these questions with relation to 1464. So what if in the sale of the specific mass, the parties did not agree on a definite number, weight, or measure? So what's the rule provided in 1464? So it says here that when what is being sold is a sale of an undivided share in a specific mass, if there's no definite agreement on the number, weight, or measure, then the rule is that the buyer becomes the owner in common of such share in the mass as will thereafter be determined when the mass is already numbered, counted, weighed, or measured. Okay, so undivided man siya. So co-ownership. Okay. What will happen, however, if, for example, once the specific mass is numbered, counted, weighed, or measured, and it turns out that it is less than the number, weight, or measure bought. So what's the rule? How do you resolve this controversy between the parties? To what extent man ang napalit? So Article 1464 provides that when there is less than the number, weight, or measure bought, then the buyer actually becomes the owner of the whole mass. All right? And the seller is bound to make good the deficiency. So seller here is still obliged to deliver the deficit. Kung nagsabot na sila and it turns out that the mass is short. Okay, so that's how you understand the rule in 1464. So how do you know then that a thing, subject matter of a sale, is already possible? So The test is whether the subject matter of the sale is of such type and nature that it can be manufactured and could come into existence, taking into consideration the state of technology and science at the time of the perfection of the sale. So if the thing exists or could be made to exist such that the seller is allowed a reasonable certainty that it can comply with the obligations under the contract, then that is considered as a thing that has possible existence. So the test, therefore, is not that the thing will certainly come into existence, but that it has the capacity to come into existence. So if it doesn't pass this test, guys, then it is considered that the sale is one of an impossible thing. So the contract will be void, therefore, under Article 1409, subparagraph 3. Okay, so that's how you determine whether 1409 subparagraph 3 is applicable when dealing with subject matter of a sale that is not yet in existence and in possession of the seller at the time of perfection. So you consider the technology. Panangitan ang ilahang gibaligya or the parties are contemplating the sale of prototype hoverboard. So if this sale happened back in the 1980s and earlier, it's not possible actually, because given the state of technology, hoverboards could not be invented or even a prototype na mahimo nila na functional. It's not possible given the time. But in this year, 2021, we already know the prototype hoverboard, and in fact, a functional hoverboard has already been invented. Okay, so that's already a valid subject matter of sale. So in the case of Spouses Villaluz versus Land Bank of the Philippines, we see here how the Supreme Court harmonized the law on sales with respect to the general law on contracts and obligations. So in this case, court here said that this apparent conflict should be resolved by interpreting that the phrase found in 1409, that for those costs or consideration that did not exist, should be interpreted as one that could not come into existence. So they applied the basic rule in statutory interpretation that all parts of the statute, like the civil code, should be harmonized and reconciled. So in Article 1461, guys, we deal here with the sale of a thing with potential existence. Okay, so it's also called the sale of emptio re spirate. Okay, and when there's a sale of a thing with potential existence, we're actually dealing here with a future thing. And this kind of sale is subject to a suspensive condition. And what is that suspensive condition? That suspensive condition is that the thing should come into existence, future thing man. So the price here will be payable once the thing will come into existence. So if the condition is fulfilled, that the future thing has indeed come into existence at a later point from the perfection of the contract, then the contract is, the sale is considered as valid. Okay, but if the suspensive condition is not fulfilled, if the future thing did not come into existence, then the contract is deemed extinguished. Okay? It's as if no contract was entered into by the parties. So this kind of sale of a thing with potential existence, or emptio res parate, we have to distinguish this with emptio spe, or the sale of hope or expectancy. So you can sell hope there, guys. Okay, hope. Isn't that like an emotion, a state of mind, something that's intangible? So actually, it's just a fancy or dramatic characterization of this kind of contract. But this sale of hope, there's a physical embodiment of this kind of sale. Ang classic example ani is the sale of lottery tickets. So once you purchase a lottery ticket, you just get a piece of paper, correct? But that piece of paper, it actually symbolizes your hope of winning in the lottery. So it symbolizes that you have a chance of striking it lucky and winning that pot money. So this kind of contract, it's considered as dealing with something that is already in existence, a present thing. As long as there is indeed a lottery that will be conducted. So there's no condition attached to this kind of sale. Since the hope is already existing at the time of perfection, at the time that you purchased that lottery ticket. So the price is fixed and it is to be paid by the buyer regardless of whether or not the thing that he had hoped for will happen. So whether pildi siya or daog, bayad yun siya daan sa lottery ticket. And this kind of sale is considered as valid. However, the sale of a vain hope or a vain expectancy, this one is considered as void because it deals with an impossible thing. So the thing could not possibly come into existence. So kuangan ang usa ka requisite of a valid subject matter. So that makes it void. So let's take a look at Article 1465, which is the sale of a thing subject to a resolutory condition. So you're already familiar with the pacto de retro sale, right? Sale with the right to repurchase. So that's one example of a sale of a thing subject to a resolutory condition. So what's the consequence if the resolutory condition happens? Then, as provided under Article 1190, the parties must return to each other whatever they have received. Okay, but the fruits and interest, while the condition has not yet happened, shall be deemed to have been mutually compensated. So therefore, the parties are entitled to receive whatever fruits or interest that they obtained or derived before the happening of the resolutory condition. So in a valid pacto de retro sale, kung before the period for repurchase expires, then the purchase price received by the seller and any interest earned by it will pertain to him. On the other hand, if when on the part of the buyer, since there is delivery of the land to him, and if the vendor or retro will thereafter exercise the right to repurchase, then the vendee or retro will get to enjoy the possession of the property before the resolutory condition happened. So naka-stay siya, so na-enjoy niya ang property before the repurchase. So the agreement, the pacto de retro agreement would include na the period na ni stay si vendee or retro in the property can be assessed with rent. In addition to the purchase price, kay di ba si vendor or retro, mubayad man siya sa repurchase price. So it could be less of the rents na maoy bayaran ni buyer. Does that make sense, guys? I hope it does. So second requisite of a valid subject matter is licit thing. So take note that Article 1459 has two clauses, and we deal first with the first clause, which provides that the thing must be licit. So licit, we know this, it's not outside the commerce of men, not contrary to law. And in case of sale of rights, the right must not be intransmissible. So double negative. Therefore, you can only sell rights which are transmissible by nature. So what are these? What are some of the sales prohibited by law? So I've listed here 12 examples. So the effect if you sell these things is that the contract is null and void pursuant to Article 1409. So sale of inheritance, guys. We take note here that future inheritance is prohibited to be subject matter of sale. Why man? Buhi pang imuhang manahan, imo na ibaligya. So that's clearly immoral and against public policy. So therefore, you cannot sell future inheritance. So I assigned a case for this, ACAP versus Court of Appeals, wherein the principle is that hereditary shares can be the valid subject matter of sale, provided that, of course, the decedent has already passed. So that's when your hereditary rights will be transmitted from the decedent to the heirs. Now, take note, guys, that when similar to what happened in the case of ACAP versus Court of Appeals, there's a difference between waiver of rights and sale of rights. In waiver of rights, you are renouncing your right to inherit from the estate of the decedent. Okay, but you are waiving it in favor of your co-heirs. So if that's the case, but you actually intended to sell the property to a third person who is not an heir, is not a co-heir, then execution of a mere waiver of right is not sufficient to transfer ownership to that third person. So the proper agreement or contract that must be executed by the heirs will be extrajudicial settlement with deed of sale, not simply waiver of rights. Okay? The third requisite of a valid subject matter is that it must be a determinate thing. So how do we know that a thing is already determinate? So it is determinate when it is particularly designated or physically segregated from all others of the same class. So that makes the thing already specific. And this requisite of being determinate is satisfied if at the time that the contract is entered into, meaning at the time of perfection, the thing is capable of being made determinate without necessity of new or further agreement between the parties. Right, so when we speak of determinate, we are referring already to things which are specific. But if the subject matter are generic things, then the standard required is that it must at least be determinable or capable of being made determinate. without new or further agreement between the parties. So what's the purpose why the law requires that the subject matter should be determinate? So it is the basis upon which to enforce the seller's obligation to deliver. Okay, kung maro-maro ka nga seller, wala nimo gi-specify nga the subject matter is a generic thing. Nga if that generic thing is lost, what's the rule if can generic things be lost? Isn't the rule that generic things can never perish? It cannot be lost. So if you do not fix the subject matter, make it determinate, then there's no basis for the performance of the obligation on the part of the seller. You cannot prove that there was a breach on the part of the seller. Okay, wa man na fix ang thing. So when the subject matter is determinate or specific, the defense of force majeure is applicable and can relieve the seller from the consequences of failure to deliver the subject matter of the sale. So if before if before delivery the subject matter has already been lost and that subject matter is still a generic thing, then ma-relieve si seller to deliver the subject matter. It will relieve the seller if the subject matter is already made determinate. But if at the time of the failure to deliver the subject matter, the thing is still generic or determinate, then what happens is the obligation will remain. So kung determinate o specific na siya, that's in favor of the seller in case there's a force majeure event. So we use two tests to determine whether the subject matter is already determinate. We have the capacity to segregate test and the no further agreement test. So illustrative cases for this is Medliza versus City of Iloilo and Atilano versus Atilano. So what happened in the case of Medliza versus City of Iloilo is that the court held that the subject matter in that contract was already determinate. And they were able to reach this conclusion because they referred to the Arellano Plan. So in this case, guys, this Arellano Plan, by virtue of this Arellano Plan, the area needed or the subject matter of the sale can be ascertained because it says in the plan that the area needed for the City Hall site and the specific mention of the lots covered by the sale already fix the corresponding location of the City Hall. So it could be easily determined then, according to a given formula, how much of the portions of land contiguous to those named were needed for the construction of the City Hall site. So there's a basis at the time of the execution of the contract for rendering determinate said lots without need of new or further agreement between the parties. And in the case of Atilano versus Atilano, so what happened here was that the contract of sale, lahi ang lots na gibutang dito that will be given to the buyer. Because the lot here was subdivided into, I think, 5 lots. And at the time of the subdivision and the execution of sale, one of the buyers of the lot came to occupy a lot different from what was designated or denominated in the contract. So the Supreme Court here had to resolve whether is there a need to reform the contract of sale so that makorek. Okay, sayop lagi ko no ang na-occupy. So ganahan ang katong nakadiscover sa anomaly na mag-ilis sila, mag-swap sila sa katong ni-occupy sa iyaha kunong lot. So the court ruled here that there is one doctrine, and that doctrine provides that one sells or buys real property as he sees it in its actual setting and by its physical metes and bounds, and not by mere lot number assigned to it in the certificate of title. So therefore, guys, at the time of the sale, wherein the property was subdivided into 5, and the buyers there of the 5 lots entered into possession of their respective lots, notwithstanding na ay sayop or error or mistake in the designation of the lot numbers in the contract of sale. At that time, nagtinudluay to sila kung unsa nga lot ang ilahang paliton. So, the court ruled here that the true contract, so the concept here, guys, the principle, the important principle is that the true contract of sale is intangible or properly a legal concept, and the deed of sale is merely evidence of the contract. So when the deed fails to cover the real contract or the true meeting of the minds, then the deed must give way to the real contract of the parties. There's no need at all to reform. Mag-agad ka sa what is the real situation between the parties. So the defect in the final deed would not work to invalidate the contract where all the essential elements for its validity are present and can be proven. So how about quantity? If there is no agreement on the quantity of the subject matter, will that affect its status as being a determinate subject matter of sale? Naa by consequence kung wala gi-specify ang quantity, will it affect the determinateness of the subject matter? So I'll continue the discussion in another video. So stay tuned.